Good morning, everyone, and welcome to our MIOSHA and COVID-19 webinar. This is part one of our safety series with regard to this topic. This is Sarah Willey from Miller Johnson, and I'm here with my colleague, Sandy Andre. And we're going to be talking to you guys for half hour, 45 minutes this morning about MIOSHA and safety standards as it relates to COVID-19. Sandy and I decided to put together this series because in the last couple of weeks, we've seen several complaints that employees have filed with MIOSHA and have lived through several of those investigations. And it's become, I think, more clear to us that going forward and over the next several months, probably a lot of businesses and employers are going to be thinking now about MIOSHA compliance. We've gotten over the hump, many of us, with regard to return to work and getting our preparedness plans in place, et cetera. And now that we have folks at work and working on a regular basis, MIOSHA, I think, is going to become front of mind for all of us. So I wanted to talk to you today about MIOSHA in general, and I want to share with you what our series is going to look like. Today, we are going to be talking about MIOSHA enforcement and the general duty clause. So we're going to explain to everyone what MIOSHA is, how does it interact with OSHA, what's the difference between the two, what sort of powers do they have. And we're going to talk to you about what standards, what safety standards from MIOSHA and OSHA apply to COVID and what that means with regard to what all of you should have in place now, okay? Next week, next Thursday, we're going to be talking specifically about what we call the 3 R's. Reporting, recording, and records. So with regard to COVID, what do we have to report? What do we have to record? And what records do we have to keep? And with regard to recording, the biggest issue and concern is when an employee tests positive for COVID, do we have to record that in our OSHA log? So we're going to be talking specifically about that next week. And then the following week, sort of our grand finale on July 29th, we're going to be talking more specifically about MIOSHA standards that apply to the COVID-19 pandemic, okay? So this week we're going to focus higher level on MIOSHA, and we're going to talk about what you should be doing now to prepare for a MIOSHA investigation or complaint. We're going to be taking questions at the end, so if you have a question, go ahead and type it in. We've already gotten at least a few of those, and so we'll be taking those after we present the material. And with that, I'm going to turn it over to Sandy.
Okay, thanks, Sarah. Good morning, everybody. We're going to start by just talking very briefly, giving you a very brief overview of MIOSHA. So MIOSHA obviously is an acronym. It actually stands for 2 different things, right? The first thing it stands for is the Michigan Occupational Safety and Health Act. So that act was put in place in Michigan in 1975 and essentially is the Michigan statute that requires employers to provide a safe work environment that is free from recognized hazards to its employees. So within that statute, there are certain prescribed working conditions that employer duties, so to speak, employers must provide, and then there are certain duties that employees must abide by. And the Act itself provides a mechanism for the Michigan Occupational Safety and Health Administration, as well as the the Department of Labor and Economic Opportunity is the Michigan department that MIOSHA is under now, to promulgate specific standards. So a standard under the MIOSHA Act, right, under the MIOSHA Act, has the force and effect of law, presuming it went through the correct process to become so. And so it's those standards that employers have the duty to implement in their workplace. So before you can be cited for a violation under MIOSHA, there is a specific standard that you must be in violation of or out of compliance of, or you may be in violation of the general duty clause. So the general duty clause, this might be the one that you've heard a lot about during the COVID-19 pandemic. That is the overarching duty of an employer to furnish each employee a place of employment that is free from recognized hazards that are causing or are likely to cause death or serious physical harm to the employee. So generally how that works, if there is not a specific standard that has caused an unsafe working condition, right? So you can't turn to the MIOSHA Act, or there's not a specific standard that's been promulgated under MIOSHA to say, okay, this is you're out of compliance here, and that's kind of what caused this dangerous working condition. MIOSHA can then take a look at your obligations under the general duty clause and determine, was that a hazard that the employer should have recognized? Was the hazard something that was likely to cause death or serious injury? And was there a feasible or useful method to correct that hazard? So that's generally the duty under that general duty clause. In terms of standards, there are two groups of standards. One, the standards that are grouped under the general industry standards section, and so those apply generally to most employers. And then there are additional standards that apply to construction industry standards. Now, the construction industry standards, I say generally apply to construction employers. However, they can also apply to employers who you and I wouldn't think of as construction industry employers, but whose employees may be doing certain construction type work, okay? So generally, if you're looking for a standard to say, hey, is there something under MIOSHA that I have to follow related to how this type of work can be done, those are the places that you would be looking. Next slide, please. So along with the enactment of MIOSHA, we have the second acronym MIOSHA stands for, the Michigan Occupational Safety and Health Administration. So as I mentioned, this is an agency within LEO, the Department of Labor and Economic Opportunity. And so this is the department that enforces the MIOSHA Act, okay? And so it's generally organized into a number of divisions. So there's a General Industry Safety and Health Division, and that's the group that is in charge of enforcement related to those general industry standards. So that group conducts inspections, investigation in the workplace, responds to complaints, investigates accidents, responds to referrals of unsafe or healthy conditions. That's that group's primary job. There's also a construction Safety and Health Division, very similar, does the same thing but related to construction standards, right? So deals with, again, conducts inspections, responds to complaints, those types of pieces. MIOSHA also has a Consultation, Education, and Training Division. CET is the acronym that goes by. And so that particular division is made up of non-enforcement personnel, and so it's in-house staff that provides occupational safety consultants or occupational safety specialists, industrial hygienists, those folks to provide consultation and education throughout the state to different employers. There's also an appeals division. So in the event that you get a citation from MIOSHA, this is the group that you would deal with to appeal that citation or work your way through the administrative hearing process. Within the General Industry and Safety Division, there's also an employee discrimination section. So this section is specifically focused on investigating complaints by workers who have been allegedly discriminated against for exercising rights under MIOSHA, right? So this is an employee who says, I spoke up about a safety concern and I was disciplined, you know, later on, at some point later on, and I believe my action of voicing a safety concern is what led to my discipline. So that's a little bit different than my employment is unsafe because my employer isn't doing X, Y, or Z. So that's the difference there. And then there, of course, is a technical services division, and that group mainly deals with compilation of statistical information, coordinates activities regarding moving proposed standards through the promulgation process in those pieces. So that's a really quick snapshot of what the MIOSHA, the administration side, looks like. Next slide, please. So the next question we get a lot is related to what is the relationship between OSHA and MIOSHA. So we all know OSHA is the Federal Occupational Safety and Health Act and Occupational Safety and Health Administration that was developed in the 1970s. So OSHA regulates, really was the first comprehensive attempt at approving occupational health and safety standards at the federal level, and created the Occupational Safety and Health Administration. And essentially that, the initiation of federal OSHA replaced kind of this piecemeal approach of state and federal laws. So there are 28 states that have OSHA approved what's called state plans. So within federal OSHA, there's a provision that provides that states may have their own OSHA approved state plans as long as the state's standards and enforcement programs are at least as effective as OSHA's. And so Michigan is one of 28 states that has such an OSHA approved state plan. So state plans can have different requirements, but generally they must be more stringent requirements, right? And so as we look at MIOSHA specifically, many of the MIOSHA standards are identical to the federal OSHA standards. And of course, federal OSHA retains jurisdiction in Michigan for federal employees in certain specific types of operations like mining operations or the maritime industry or even workplaces on Indian reservations. So here in Michigan, we look first to MIOSHA because we know that they have enveloped everything that would be required at the federal OSHA level. Okay, next slide, please. So now let's specifically talk about MIOSHA and COVID-19. Next slide, please. So as we look to enforcement, there are no specific COVID-19 standards that either federal OSHA or MIOSHA have promulgated. So you may have seen some things in the news where federal OSHA is being lobbied, for lack of a better term, right, by a number of groups to pass emergency temporary rules under federal OSHA, but none of that has happened yet. As it specifically relates to MIOSHA, a couple important happenings here for us. So you may have remembered back in June, the Michigan Court of Claims determined that Executive Order 97, there's a portion of it that was unlawful to the extent that it deemed a violation of the workplace safety standards in that executive order a per se violation of the MIOSHA Act. So if you remember Executive Order 97, it actually started as Executive Order 91 back in May, but by the time we got to court in June, it was 97, and actually what exists now is Executive Order 145. And so that's the safeguards to protect Michigan's workers from COVID-19. That's that executive order, right? So it's the one with the long list of rules, that all businesses must do this, but construction industry must do these additional pieces, manufacturing must do these additional pieces, outdoor employers, restaurants and bars, so on and so forth. So that's the executive order we're talking about. And when it was first signed back in May, it contained a provision at the very end that was a little bit different than the previous executive orders that talked about, a violation would be a misdemeanor under the Emergency Management Act or Emergency Powers of the Governor Act, those pieces. That executive order indicated that a violation of one of the requirements in that executive order was would be seen as the employer failing to provide a place of employment that was free from recognized hazards that was causing or likely to cause death or serious physical harm to an employee. And so we know that language, right? We know that that falls under generally the general duty clause. And so essentially that executive order started out as saying a violation of any of these workplace rules is a per se violation of the MIOSHA Act. So in June, the Michigan Court of Claims declared that that section of the executive order was unlawful. And so now we have Executive Order 145 that was just issued last week, acknowledging that Michigan Court of Claims decision. And so Executive Order 145 has removed that part of the reference to the MIOSHA Act violation. So that's a long way of saying, okay, that's all great, Sandy, but what does that mean? Does that mean I don't have to follow these things anymore? What does it mean? So really the Court of Claims decision, if you remember, the long list of rules, I always use this example. One of the rules was water fountains. I don't know why this one sticks out to me, but it does. And so instead, certain facilities were not allowed to have, they had to turn off all of the water fountains. They couldn't be operational. So the Michigan Court of Claims decision, instead of saying that the water fountain, right, is the hazardous condition that an employer, that is the recognized hazard in the workplace, that the employer, if they don't close it down, has committed a per se violation of MIOSHA. The focus is back on COVID-19 being the hazardous condition that the employer must now attempt to abate, and it's going to look at the employer's good faith efforts kind of from a totality of the circumstances type of standpoint, look at all the things that they are doing to try to abate the COVID-19 hazard in their workplace. Next slide, please. So all of that to say, let's now go through, okay, what are the what's then? What do I need to do? So we just talked about there are no existing COVID-19 MIOSHA standards, but there are existing MIOSHA standards that can apply to the COVID-19 situation, okay? And so you see a list of them there. The personal protective equipment standard, the sanitation standard, respiratory protection, hazard communication, access to employee exposure and medical records, and then the recording and reporting piece. And so all of those there that are pointed there, we are going to discuss actually in subsequent webinars. We're going to spend kind of the meat and potatoes on our requirements under the general duty clause today. Okay, so remember, the general duty clause means the employer has failed to keep the workplace free of a hazard, that employees are exposed, that hazard is likely to cause death or serious physical injury, and there was a way that the employer could have corrected that. Next slide, please. So as we look to, that's a pretty broad requirement, right? So we've all kind of gone into the pandemic going, gosh, I'm really trying to get my hands around what my obligations are from an occupational safety and health standpoint, and I feel like all I'm left with the general duty clause, and it's really this big gray area. So what we do now is we look to, okay, what has MIOSHA told us about how they are going to evaluate our compliance under the general duty clause. And so back in June, they updated, they've issued a couple of interim enforcement plan documents throughout the pandemic, and the most recent update was in the middle of June. And essentially this enforcement plan document is an agency instruction document, right? So it's intended to, the intended audience is agency personnel. But the agency itself is saying, okay, personnel, these are the policies and procedures that we are going to follow in terms of how we handle referrals, complaints of alleged hazardous conditions related to the coronavirus, fatality reports, all of those pieces. So this is kind of the enforcement plan, and this is the backdrop I would encourage all of us to use as we think about how what it means to be compliant with our duty under the general duty clause in kind of this weird COVID-19 pandemic time. So you'll see that in their enforcement plan, they specifically reference the personal protective equipment standard, the sanitation standard, and the respiratory protection standard, which we'll talk about in a couple weeks. They also reference a number of OSHA enforcement memos that federal OSHA has also issued, right, enforcement memos saying this is how we're going to interpret these standards during this pandemic time. But MIOSHA has also said there's additional guidances that we're going to look at to help us make the determination of whether employers are meeting their requirements under the general duty clause. And those are executive orders related to COVID-19. They are related to the OSHA guidance on preparing workplaces for COVID-19, and they are general guidance issued by the CDC. So the good news for all of those, hopefully everybody on this call is pretty well aware of all of those sources. And so now it's just making sure that we have filled in the detail on how we think about our responsibilities under each of those pieces. Next slide, please. So let's first attack executive orders. So as I mentioned, I think as of yesterday, we were up to 150 executive orders here in calendar 2020, and all but a handful of those are specifically related to the COVID-19 pandemic. So if you're listening to this and you're saying, gosh, Sandy, I can't keep all of that straight, I hear what you're saying, and I appreciate and can understand that because it's a constantly moving situation, right? In fact, as we were working on some of these slides, some of these numbers changed because orders were rescinded and reissued and with some changes. So this is kind of the approach that I think that we want you to think about how to eat this elephant, okay? So let's take just a quick review. Executive Order 2020, 110 and 115, those are the executive orders that give you the ability to be operating, right? So wherever we are in Michigan, right, whatever region we're in, if we're doing in-person work or the way that we're working, we look to first Executive Order 110 or 115 to say, hey, am I even allowed to be working? And in what capacity can I be working? You know, does our organization have capacity restrictions? When can we operate? All of those pieces, right? And so then it's Executive Order 145 that is the general safeguards to protect Michigan worker orders that has a number of sections and has some industry specific requirements, and we'll talk about those in just a second. But generally, I want you to think of 145 is how in-person work must be conducted, right? 110 and 115 says, am I allowed to do in-person work? And 145 says, if I am, this is how it must be conducted depending on what industry I am. But it's also really important to remember that Executive Order 145 is not a one-stop shop for all in-person work requirements, right? There are a number of industries that have specific executive orders that require additional safeguards for their employees and or their customers, and we've listed some of those executive orders here. So specifically food selling establishments and pharmacies, long-term care facilities, if you're a correctional facility, pre-K through 12 education for the 2021 school year, right? The Michigan roadmap to return for education, that's important. Migrant and seasonal agricultural workers and healthcare facilities. So that's just a sample of some of the executive orders that require additional safeguards for employees in those areas or customers, clients, residents, those pieces. And of course, Executive Order 36 is the protecting workers who stay home and stay safe when their close contacts are sick. So that's the executive order that allows employees, if they are experiencing, if they have a COVID-19 diagnosis or they are experiencing symptoms of COVID-19, they have the ability to stay home from work, and that's job protected. Or certain employees, if they have come in close contact with somebody who has contracted COVID-19 or is symptomatic for COVID-19, they also have the ability to stay home from work, and that's job protected leave. Next slide, please. So those are the general executive orders that we want to keep in mind as we think about our general duty clause requirements. The next document that the MIOSHA enforcement document specifically references is the OSHA guidance on preparing workplaces for COVID. So the good news about this is probably everyone on this call, this is a very familiar document because this has been in our lives here in Michigan since April, right? When one of the executive orders specifically required all employers who were back to in-person work to develop a preparedness plan that followed generally this specific document that is a joint document for both the CDC and OSHA. So hopefully this is a familiar document to you, but essentially says how do you have your preparedness plan that Executive Order 145 requires, but does it have all of the pieces? And whether it has all of the pieces, MIOSHA will look to this OSHA CDC document to kind of determine if you've checked those boxes. So in terms of a preparedness plan, if you have just recently resumed in-person operations or you're not there yet and you need help developing that, I would point you back to a webinar that we completed on April 14th that we went through all of the nuts and bolts of what we would recommend being in your preparedness plan. We also have industry-specific templates available in our resource center if that's something you're interested in as well. But remember, Executive Order 145 requires that within 2 weeks of resuming in-person activities, your business or your operations plan must be readily available to employees, to labor unions, and to customers, whether that's via your website, some kind of internal network, or by hard copy. So making it available and posted, that is a newer requirement that's kind of come on in later executive orders that didn't exist in that initial executive order that required the preparedness plan. So don't miss that piece as well. Next slide, please. And so then as we go back to, again, that MIOSHA enforcement memo, that last piece that they reference is the CDC. So I'm sure everybody on this call is more than familiar with the CDC website and is going there often to see the latest and greatest recommendations. One thing to remember about the CDC, of course, and the information there, and I'm not suggesting that we don't follow those things, but it is just guidance. So unless an executive order has made following CDC guidance mandatory, from a MIOSHA standpoint, CDC materials on COVID-19 are not mandatory for an employer. You don't have to do those pieces. But there are some executive orders that have specifically referenced CDC guidance in a couple of ways. An easy example is when we're talking about employees who may have tested positive for COVID-19, right? So we have an executive order that specifically says such an employee is eligible to return to work only once they have met the CDC requirements for safely returning and have been released from any any kind of quarantine order from their healthcare provider, so on and so forth. So unless there's an executive order like that that specifically requires those CDC guidances or guidelines to be followed, I want you to think about those as guidance type of document and recommendations rather than requirements. Next slide, please. So now let's talk a little bit about what we're seeing. As Sarah mentioned at the outset, we developed this series kind of in response to our clients being contacted by MIOSHA related to some of their preparedness related to the COVID-19 pandemic. So to be clear, MIOSHA is permitted to do inspections, right? Either scheduled type of inspections that are in response to alleged dangerous working conditions or what they're called program inspections, which are generally kind of based on random selection criteria and are generally only in specific industries. However, there's kind of a priority list for when MIOSHA determines whether it's going to do an on-site inspection or what they call, what I'll kind of colloquially call a telephone type of investigation or a letter type of inspection, right? And so obviously those on-site inspection priorities are generally related to fatalities, when employees are imminent danger, when they're doing some ongoing monitoring or following up from previous citations. So generally what we've seen kind of in this COVID-19 world, if we're just specifically talking about what I guess I'll call kind of run-of-the-mill complaints, right? An employee says, hey, my employer is not doing fill in the blank. We've generally seen our clients be subject to kind of what we call a letter inspection. So MIOSHA will make some contact with an employer representative. The employer is asked to provide a response related to the specific complaint that MIOSHA is investigating, and usually there's a pretty quick turnaround on when that response is required. So the employer responds and sends in any documentation that's been requested, and then MIOSHA will make a determination whether it's kind of satisfied with the response the employer has provided in the documents that the employer has provided, and either closes the investigation or determines that additional investigation is necessary, and that can include on-site inspection. So generally what we've seen related to COVID-19 compliance have been letter inspections that have specifically been related to a handful of things, and these are kind of themes we've seen over and over. So these should kind of be on your short list to make sure that you've got your process and procedure in place, as well as your good record keeping, right? So it's specifically related to COVID-19 training. So we know that Executive Order 145 specifically requires employees to be trained on a number of COVID-19 related topics. Some of those are, infection control related type of topics, but some of those are just generally how, I'm an employee, how do I report an unsafe working condition? What do I need to do if I come in contact with somebody who's COVID positive? Those types of training pieces. So 145 requires the training and record keeping related to that training. So that's something we've been seeing. Some complaints just generally related to social distancing requirements or mitigation strategies. So as an example, my employer hasn't installed sneeze guards at the cashier station, or they didn't until X day. And so asking the employer to respond to that. My employer hasn't provided me the appropriate PPE, or even just general face covering type of complaints, which doesn't hit the PPE level from a MIOSHA standpoint, but my employer isn't providing us face coverings or isn't requiring us to wear them, even though the executive order says we have to, those types of pieces. Several pieces specifically related to the daily entry screening protocol. So again, depending on what industry you're in, that can kind of be a self-screening, right? But it's before employees come into the facility, right? So, whether it's a temperature screen, but I'm asking you, are you currently experiencing symptoms? Maybe have you recently had close contact? And depending on how you answer those questions and what industry I happen to be in, either requires me to keep you out or allows me to have you come into the facility and work. And then employers, of course, need to keep records related to those entry screening protocols. Some complaints specifically related to an employee, was able to access the facility because they weren't experiencing a fever, hadn't been experiencing any symptoms, but became symptomatic while at work. And I don't think my employer isolated that individual quickly enough or exited them from the facility quickly enough. So some inquiries related to that. Several inquiries specifically related to the positive test protocol, right? So we know now Executive Order 145 requires certain notifications to the health department initially, an immediate notification to the local health department, but then also notification to any employee who may have had contact, not close contact, but contact with that individual, and then obviously subsequent notifications and working with the health department related to those who may have been in close contact. So several inquiries about that process and when notifications happened. Certainly some industries have additional notification requirements to vendors and contractors, customers, even in some situations. And then we've had a couple of inquiries specifically related to on-site work. Generally, these were a little bit earlier in the pandemic, right, when we were kind of all operating under that kind of critical infrastructure type of framework. Hey, my employer has classified me as critical infrastructure and I don't think I am, so they require me to work on site. And so MIOSHA inquiries related to how the employer did that analysis. So those are generally the types of enforcement activities that we have been seeing. And so if we go to the next slide, we're going to provide you a checklist of how we recommend you remain compliant based on kind of the enforcement activity we're seeing. This is kind of a short list for you to go, yep, we've got it, and I've got all the record keeping related, okay? So the first piece is the preparedness and response plan. So it's first, right, having the document, making sure that it is written kind of with that OSHA CDC document as a good starting place, and making sure that you're publishing that as appropriate. Making sure that you are completed COVID-19 related training. We talked about Executive Order 145. That is a great place to start. There's a training requirement that is applicable to all industries, but there's some industry specific training that Executive Order 145 requires as well. And so it's making sure that that training is completed and you're keeping records on those pieces. The second piece on the training is making sure that you stay abreast of any new training requirements that may come down the pike, right? So, for example, we're talking about Executive Order 145. That executive order started as Executive Order 91, so it's gone through a number of iterations. And so it's making sure that you're kind of keeping an eye on what all those iterations are. And if a new requirement comes on the scene related to training or anything else that we're talking about today, that you're kind of doing a doubling back of going, okay, we've trained, a certain portion of our entire workforce, and now there's new requirements. And so what are we doing in our workforce to kind of circle back to everyone who got the initial training to make sure that we give them this new piece of training as well? That's really important. The daily entry screening protocol, we're required to have it under 145, but it's really important that we keep that tight. So I think, again, when not as many of us were back to on-site work, this was a little bit easier to monitor, right? Maybe there was only a handful of people that were ever working on site, and so it was really easy to make sure that we were keeping track and nobody was in the facility before those things were done. And depending on, how your workforce is laid out, right? If you've got 3 specific shifts with specific start and end times, maybe that's a little bit easier than when you have people coming and going. So making sure that you really take a look at that protocol and keeping that really tight to make sure that that folks are doing that before they come into the facility, that you've got the records that support that. Cleaning and disinfecting. A number of requirements in Executive Order 145, but the CDC obviously has a lot of great guidance related to products and different types of strategies that you could use to meet your obligations there. Again, social distancing and mitigation strategies, markers, physical barriers, those types of pieces, making sure that you're in compliance with those pieces. 145 also requires designation of a worksite supervisor, and although that feels like a have to do, that's actually really helpful in a number of ways. If you're kind of making sure that you're doing that designation and your employees know who that is, it's a great person for your employees to go to if they have any specific type of concern, in making that person, not necessarily the person who needs to solve the world's problems related to whatever the complaint is, but that you've got a good system of here's where complaints can go, and this is what our organization does, as we receive them, in terms of what we do to investigate whether the complaint, how we rectify all those pieces. Communication, so we're talking about postings and policies with the Executive Order 145 that just was updated again last week. There's now a posting requirement in that executive order that's brand new, and so making sure that we're staying aware of those pieces. If you're looking for a poster that meets the requirements of 145, we have one in our resource center too, so you can always look there for some of those, the latest and greatest. Similar to the daily entry screening protocol, making sure that our positive test protocol remains really tight. Again, when we look at kind of that safeguards order, when it started as Executive Order 91, there's a number of things that have come into that in each subsequent iteration, and some of those pieces relate specifically to how the employer responds to notifications that one of its employees has tested positive. And so there's quick turnaround related to notifications that you need to be doing to local public health officials and those in your workplace. Obviously, face coverings, face shield, hand sanitizer, those pieces are in that executive order as well, making sure we're following those, and then looking to the remote work and making those essential travel type of designations are also a piece of Executive Order 145. As you look at industry-specific requirements, we know Section Executive Order 145, Section 2 through 14 have a lot of those industry-specific requirements there, so you'll want to look there. MIOSHA also has industry-specific guidance, and I'll show you in just a second exactly where you can find that. And then there are also, the chart at kind of the beginning of this section, we talked about that there are industry-specific executive orders. We'll want to make sure that you circle back to any of those that may specifically apply to you. And remember, for example, if you're a manufacturing facility, you may have a number of those industry-specific pieces that apply to you, right? So, for example, the shop or the shop piece of your facility needs to comply with the manufacturing pieces, but maybe the offices of your facility need to comply with the office pieces. So think about the way that you're specifically set up and make the determinations of what pieces may apply to different areas of your workplace. And then, of course, OSHA and CDC specific guidance is important too. So next slide, please. So the next couple slides are really just I want to make you aware of some of those industry-specific pieces where you can go for guidance. So, for example, you've got a MIOSHA website here on the Labor and Economic Opportunity website, where MIOSHA has come out with industry-specific guidances related to restaurant and bars, manufacturing, construction, all of those pieces. Additionally, you have the CDC website here that specifically provides resources related to industry-specific types of guidance documents. And next slide, last one there, should be the OSHA website there that also has industry-specific types of pieces as well. So those are really important to keep in mind. And so the last piece to think about then is specifically related to, next slide please, why do we want to get this right? And we want to get this right, not just because it's the right thing to do, right? Of course, we want to be protecting our employees, protecting our customers, and protecting our businesses. We can go to the next slide, please. But it's important to recognize the real types of consequences that can come from not getting this right, okay? So with MIOSHA, there's a number of different types of violations and penalties that a citation can result in, right? And so MIOSHA divides the types of violations into serious or other than serious generally, even willful, repeat, and failure to abate. But generally, those violations can be maximums of $7,000 per violation. And certainly if we're in the willful category or repeat category, that can be up to $70,000 per violation. So in addition to just doing this because it's the right thing to do to keep our employees safe, there's a real dollars and cents impact related to getting this right as well. And the very last piece related to that, a great reason on why you want to get it right, next slide please, is also under MIOSHA, your employees have the ability to refuse work in certain circumstances, right? If there's a dangerous condition in the workplace that represents a risk of death or serious physical harm, there's not sufficient time for MIOSHA to inspect, and a worker has brought the condition to the attention of the employer, and the employer hasn't corrected it, the worker has the legal right to refuse work in those situations. And so as we look at the checklist that we went through, and it seems like that's such an onus on us as employers to have to do, but your compliance with all of those pieces is a great place to start, right? So if you've got an employee who just generally says, I'm refusing to work because this dangerous condition exists in my workplace, and you go back and you're doing all those things on that checklist, you're in a great place to say, no workplace can be totally free, totally safe from COVID-19 with what we have going on in our communities right now, but we're doing all the things that we need to do. And so it's just simply not reasonable for you to refuse to work. From a MIOSHA standpoint, certainly employees, will have their own comfort level to returning, but that's a separate issue. From whether the employee had the legal ability to refuse to work, from a MIOSHA standpoint, if you're doing all of those other things, you've positioned yourself really well to respond very positively to that. Okay. Have we gotten any questions?
Yes, we have gotten a handful, Sandy. I want to cover just a couple of things first. In terms of whether COVID is recordable, just a reminder, we're going to be talking about that next week in great detail. That's just, there was too much here to all cover in one webinar. But I will say this, OSHA has now published a fairly in-depth analysis of whether an employee's COVID is work-related. And so there's steps to follow that have been published by OSHA to help us determine whether or not that's work-related. And if it is, then it would be recordable. And we'll be talking more about that next week. If that's something that any of you need an answer to immediately, I'd say feel free to reach out to whoever you use as legal counsel to talk about that and how it applies to a specific example in your particular workplace. Okay, let's cover a few more questions that I got. Does OSHA and MIOSHA apply to all employers regardless of size? There is a small employer exception only for the recording piece of OSHA requirements. Otherwise, the safety standards apply to all employers. I also had a question about the response plan. There was a little bit of confusion as to whether we said the response plan has to be posted or can you make it available electronically. The executive order just says it has to be readily available to employees and unions and contractors, and that it can be done electronically, or you can give folks a hard copy. So it would be fine to have it available electronically, for example, on a website or an internal network or something like that. Another question, do we have to keep records of the daily screening? And the answer is yes. Executive Order now 145 specifically says that all employers with in-person operations have to not only do the screening, but they have to maintain a record of that. And I'm using the words that the executive order uses, the quote unquote, maintain a record. So what does that look like? What I would say from a practical standpoint is you would want to show MIOSHA what you ask in your daily screening, and you would want to know who did a daily screening on any particular day, okay? So with regard to that second piece, some employers have a process by which they know everyone who went to work that day, everyone who clocked in, They would have a record of that, and they would know every employee who answered yes to any of the screening questions, such that they weren't allowed to clock into work that day. So and with regard to those employees, they would have a record of who that was and what question they answered yes to. And so there's all sorts of different options and ways of maintaining that record. And those options are going to depend on how that particular employee is doing the health screening, whether it's done in person at the facility, for example, whether they're using a symptom checker app, etc. That answers that question as best I can without knowing more about exactly how that employer is doing the symptom. Another question, a question about schools and Executive Order 132 versus 142. I think there might have been, we apologize, there might have been a typo on one of the slides. The executive order that applies to schools is actually 142. It's not 132. Next question, do we know of a poster to cover the training requirements of Executive Order 145? I'm not sure if that individual means the training requirements or the posting requirements. Those are two separate things. Executive Order 145 now requires a posting, and that's new from prior executive orders. Yes, we do know of a posting requirement. Both the state of Michigan, Leo, has a posting that can be used on its site. The CDC also has a posting available, and the CDC has that same posting available in about 30 different languages, which is helpful. We also have all of those on our COVID-19 Resource Center. If you're asking whether there's a posting to cover the training requirement, there is not. That is, the training requirement is more in depth than a posting would allow, and it's envisioned to be more a training rather than a posting. All right. Going through, sorry, I'm pausing here. I'm going through the next question. We have a few here about ADA and refusing to work if they're concerned about their health. I'm not going to go into depth about that question, but I will say we've had a couple of webinars specific on that issue. So I would direct you back to our Miller-Johnson COVID-19 page, and we have webinars, webinars that we've done before on there. So go back to those to learn more about that. Okay, the last thing I'm going to say about today about MIOSHA investigations is this. We have been through several of these for clients, and I will say that MIOSHA is generally taking a good faith approach when they are evaluating complaints that have been filed by customers or employees. So Sandy mentioned some examples of when you might get a complaint and get a letter from MIOSHA asking for information. It appears to us at this point that they are looking for employers to, number one, know that the executive orders exist, have an understanding of what is required under them, and be able to demonstrate that your business paid attention and in good faith tried to comply with them. If you're perfect in every circumstance, it does not appear that MIOSHA is interested in nitpicking or issuing big fines for that. So one example I can give is that more than one client I had a complaint for could do all of those things, but hadn't actually done the employee training yet. Okay, so in their response, we talked a lot about everything they had done. We showed that they understood the executive orders and what was required. We said the training had not yet been completed, but we put together training and said that it was going to be completed that same week. In all of those cases, in all of those situations, MIOSHA closed the complaint without asking more questions. Okay, so I want you to understand that, because it's overwhelming sometimes to hear about all of these details. Remember, this is a good fit. You want to be able to say you're doing the best you can, you're operating in good faith, you're following the executive orders as best you can. The other piece I want to say is that there is low-hanging fruit here that you want to get right. And that is, you want to have your preparedness plan in place. MIOSHA is going to ask for that, I promise. You want to be doing the daily screening. They are going to ask for that as well. And you are going to want to have the new posting up. They're definitely going to ask for that too. So all of those things you can do now. Have that in place so that if you have a complaint, if and when you get a complaint, you're going to be able to show MIOSHA that you're operating in good faith. Let me just take one last look to see if there's any additional questions. Yeah, there's a follow-up question about if we use the phone app for health screening and the employee just keeps a record on their phone. Is that maintaining a record of the health screening? So if you follow up and require them to tell you that they did the screening via the phone app when they actually clock in, I think MIOSHA would find that to be sufficient record keeping for the health questionnaire. However, you're going to also need the actual questions that are asked on the questionnaire, right? So it's via phone app. You need to know what questions employees are answering when they're doing that, when they're following that on their phone app. Okay, so with that, we are going to leave you to your workday, and we will see you back next week to talk in more detail about the 4 R's of MIOSHA. Thank you so much for attending today.